The law matters. Yes, it does. And we're here to help you understand it a bit better. I'm Deb Moraes, your host and moderator. For nearly a decade, we've been providing information to help make legal information more accessible to you. We offer legal information, insights, some practical advice, and hope that this will be helpful to you in handling the issues that you need to as you navigate the complexities of the law. A solid understanding of the law empowers you to protect yourself, your family, and at times your business. Through our discussions, you may find that you are able to handle some issues yourself. If you decide later that you need to contact professional counsel, you'll be better prepared, and so will the outside legal counsel that you enlist. We hope to save you time, money, and of course we want you to achieve the best possible results. As always, we want to welcome again and thank Attorney David Bazar from the Bazar & Associates law firm in East Providence, who continues to weigh in on the topics that we handle in each session. Today, labor and contract law, an overview. There's a lot to cover. Contracts, there's a simple definition about that, and we'll go through that. But the simple definition ends there. It does get complicated. Also, there are many hot topics now in labor law, such as what's happened with remote work, employee classifications, pay equity, DEI issues that have impacted. So we want to cover some of those, or at least touch on them. Additionally, issues surrounding AI has further complicated the workforce, whether it impacts on the day-to-day workings or enforcement of immigration laws, non-compete agreements that we've discussed before. All of these things have certainly become a little more, maybe a lot more complex. So let's get to it, David. What is a contract?
You had a simple definition?
It's a promise between two people.
Yeah, okay.
That's as basic as I could possibly imagine.
So legally, we define a contract as there was an offer and an acceptance and consideration. So that's pretty straightforward and simple too. So for example, I offer to sell you my car for $10,000. You accept the offer. The consideration is the $10,000 that you're going to pay me in exchange for my transferring my car to you. And
that seems so very simple. Why is it such a complex issue? We know why it is, so let's delve into it. How do you know if that offer is legitimate? How do you know that there aren't other complications? What kinds of things do people need to look at when they're being offered a contract of some sort?
So there's a lot of complexity to it, and that's why the class of contract law in law school is such an extensive thing, because there are complications on what needs to be in writing and what doesn't need to be in writing. There's complexity on whether there's a valid offer, or, as you said, an acceptance. How has the acceptance been communicated? So another example is your dog got lost and you put up a sign, reward $5,000 for the return of my dog. So is that an offer? It certainly seems to be. And if someone then, in reliance on that offer, sets out to find your dog and returns it, they've accepted the offer by doing that. So now are you bound to pay that reward? The answer would probably be yes.
So it's a legal thing. It's a legal thing. So in many cases, you hear that people say, well, that wasn't really a legitimate offer. There wasn't really it was done under duress. There are so many complications with these kinds of things. And so what an adequate consideration would be, what the negotiations are. How do people grapple with it? We say that there are times when you can handle some issues yourself. In fact, you were saying there are times, we were talking about a law being, or a contract being written. Sometimes a contract doesn't even have to be written from what we understand, although
Right.
these days, the way people are so litigious, that's probably highly advisable, and I'm not a lawyer to say that, but certainly it sounds like there's an awful lot of issues that make it so much more difficult if you don't have it in writing.
Yeah, so certain things are covered by what's called the statute of frauds. And things that fall under the statute of frauds means that it's required that that contract or agreement be in writing. And all right, so this was a long time ago when I was in law school, but there was a case. And there were these two gentlemen, and they were back and forth forever about the sale of a piece of property. And the one guy who owned the property really didn't want to sell it, and the other guy really wanted to buy it, and they were back and forth. And one day they were in the bar, and they were drinking, and they were talking, and they were drinking. And it was for the sale of real estate, which is one of those things that needs to be in writing. So they went back and forth, and finally they agreed that the seller would sell, and since it's a law school example, Blackacre, to the buyer for $50,000. They described the property, the amount, when the sale would take place, and they both signed it. It was written on a napkin, a cocktail napkin at the bar. So the buyer then went and said, okay, I'm ready to close, I'm ready to buy Blackacre, and the seller said, oh, no. I'm not selling it to you. And his defense was capacity. Basically, he said he was drunk and he was high as a Georgia tree, whatever. And so they went to court on it, and the court found that it was a valid contract, that it described what was being sold with enough specificity, it was in writing, the consideration was adequate, and they both signed it. And so the capacity issue was, well, you've been back and forth. You knew exactly what you were talking about, and you knew exactly what you were signing. So that contract, under those circumstances, was found to be binding.
Oh, my goodness. Well, so if they just had that conversation in the bar, and it wasn't written on the cocktail napkin, it was a he said, she said, here's the money, I don't want to sell it, would that be binding?
No, because it was for the sale of property, and it needed to have a written agreement to that. Now, in today's age, what constitutes a writing? So you could have emails back and forth, and that is considered a writing.
It is.
So yes, so as long as there's a document that can be printed and shown, it can be considered a writing.
What is a breach of a contract?
So the example I just gave you, the fellow refused to sell the property. He said he didn't have the capacity to enter into the contract. So his refusal to sell when the buyer was ready, willing, and able to transfer the money was a breach of contract. And in that particular case, the enforcement of the breach of that contract was what we call specific performance. The court ordered the seller to sell the property.
When there is a contract or that's been drafted, not accepted yet, at what point do you feel that an attorney, a lawyer, needs to be involved? These two gentlemen at the bar certainly didn't enlist a lawyer. When does one need a lawyer when entering into a contract?
Yeah, so depending on the complexity of the contract, you should have a lawyer before it's drafted and signed. In fact, you might want to have the lawyer draft it. So, for example, if it's for the sale of a business, there are a lot of things that can go into that contract. What are we selling? Are we selling the business and the stock itself, or are we selling the assets? And those are different types of transactions for the same thing, but the complexity of them and the implications are very different. So you would want to have the advice probably both of an accountant and an attorney in deciding how to draft that and who's going to be responsible for what and what indemnifications and hold harmless agreements will be necessary and all of the other things that might go into the sale of the business. If you're going to buy a car, they have their pre-printed contract that you're signing when you agree to buy the car with the purchase price, what's included, what's not. You probably don't need a lawyer for that, but you need to be very aware of what's being included and not included.
In the past, we've talked about other contracts. For example, the cell phone. You've signed on for 2 years for this rate, or this rate being held. There are probably 14 pages of 3-point mouse type that no human being is going to read. We don't usually call a lawyer to do that. Do you even read that 3-point? No, I don't even want to know, David. But you don't always enlist a lawyer when you're signing a contract, although there's probably a good point, especially when it comes to if there's a dispute, what you can and cannot do. What are your comments about that?
So I will answer the question you didn't ask.
Okay.
If I'm doing it for myself, and it's like click the box that you read it, I probably didn't read it, even though I should, but I'm not representing myself. But if I was doing it as an attorney for someone else, then you know I've got to go through every single thing because I'm being paid to do that. So most people don't, I don't think. I think most people just check yes and agree. I think there's some issue in the law as to what would be enforceable that's in that boilerplate language and what's not enforceable. And if it's overreaching and unconscionable, I don't think a court may necessarily enforce that. But I would operate under the assumption that's whatever in there I have to deal with one way or another.
And in many cases, I think we've talked about this too as being, there's, I don't know what section it is, but at some point, if there's a dispute, the issue's about arbitration and it's binding and you are essentially, I guess the word is stuck with it. If they decide you're paying it, these are the terms, you have no recourse.
A lot of times they'll put in that you can't sue, you have to go to arbitration, it's binding arbitration. And sometimes they'll try to stick you like in Texas if you're in Rhode Island. And I think with the advent of Zoom and the internet and all of those things, a court might say, yeah, you agreed to arbitration. You should be allowed to do it by Zoom. I don't think you have to fly to Texas to do the arbitration. If it said in person, whereas it could have been done by Zoom, that might not be enforceable. That's one of those things that might be overreaching, but the arbitration itself might be enforceable.
So you're beginning to talk about technology. It probably is a good springboard for AI. If I were involved with a business and needed a contract, I'm certain that I would likely go and have a lawyer check that out. However, with the wonders of AI, there are things called smart contracts now. A digitally generated piece that's based on something that's been scraped, as they refer to, from the internet that looks like it will cover the bases as they can. It's nice, it's simple, it's automated, a press of a button, it's generated, printed out, you've got your contract. They're supposed to be making sure that this is efficient, and it's certainly automated, doesn't take time, we don't have to call you, it saves money. But what does that do to the contract law sections of a practice these days? Do you see any impact yet of that on business, or are people still saying, I don't trust this yet?
Right. I've not seen any impact, and I will say this, that I've been to conferences about AI and the law, and one of the people who spoke is the leading person incorporating AI into legal research, and in such a way that what we use in the law practice doesn't hallucinate. And you may have heard of cases where lawyers used outside sources, where AI invented cases, and this lawyer included it in his brief, and the court and the other lawyer called him on it. And so I've heard cases where people have gone back to the AI and said, this case is fake. And AI wrote back, yeah, but here's another one, and they have another fake case. So the status, as I understand it, even in some of the most advanced AI forms, is that it's a good first draft. It's not a final draft, and that there are things that need to be tweaked and looked at and changed, and that's the attorney. I don't use AI to draft, but if I did, that's what our role would be. And so using it as a non-attorney, you don't necessarily even know what you're missing.
True. And at the same time, I'll tell you, am monitoring AI for not just what I do, but for clients and what AI is getting better, granted. And without citing which ones, there are some of the AI platforms that will also respond to, please cite the sources. So if you care to do the deep dive and check that source, which some don't want to do because that's why they were using AI in the first place, so that they could save themselves some time. That might have been fake, but if you cared to do the drill down, you would find that. But not everybody's doing that. Okay, so let's talk about contracts in terms of work. We've talked in the past about non-compete clauses, but before we talk about that, just about a work contract. The nature of work has changed drastically. I guess most recently the COVID epidemic certainly fast-forwarded a lot of WFH working from home and more freelancers and what. So that has impacted on contracts with one's employer anyway. How do you see that being changed now in a way that's helpful to the employer as much as it is to the employee?
So a true employee-employer relationship in certain fields, there's an ability for people to do some work from home. I think part of the issue is there's a loss of some of the community and exchange that can be helpful for a practice. So, for example, if a paralegal in a law office can take work home with him or her and do some of the work at home, it's really important, at least in most of the practices I'm familiar with, that they come back and go through that with the lawyer to say, is this correct? Do I need to change this? What do you think about? Let's talk through some of these issues. So there is a place for someone to be able to have that ability to do some work at home, but in that instance, it should be a hybrid situation.
So to that point, one of the other issues about AI and the problems that it causes, protecting privacy and data. If something is done with AI and it's out in the wild or out in the universe, there's concerns about that. If someone is working now from home and more people are working from home, how does the employer, wanting to be compliant, you have tight regulations on even your emails to make sure that they stay secure. Now that this back and forth, where it's going through 6 different parties, one's in California, who's in New York, and you're in Rhode Island, keeping hold of that privacy and protection, you're doing your best, but do you become more liable? Does the employer become more liable for those kinds of things that they can't even control?
Yes, so many, again, in this true employee-employer relationship, if you're working in the office, oftentimes you're working in a network or platform that is secured within that. Many of those things now are cloud-based.
Yes.
And so it doesn't matter whether your computer is accessing it at your office or at your home, it's the same protection. So I don't think that really creates, in that circumstance, much of an issue. So
compliance and regulations are changing all the time, more now than ever before. How is it, if you are working with someone in drafting their employment contracts and other contracts, how do you, how do attorneys stay up on every compliance and regulation that's being changed, debated, Rhode Island, Mass, and across the country? How does that happen, even though the wonders of technology do make certain advancements possible and expedite things?
Right. Yeah, so certainly if that's your field, you would be aware of changes in the law, new cases, that type of thing. I draft a lot of trusts and wills and that type of thing, and so I use a platform that will update my forms, and I'll read through why they're being changed for changes in the law. So that is something that an attorney standard of care would require them to make sure that whatever field they're practicing in, they're keeping up with whatever changes there are.
And a lot of them are still in flux. So let's talk about remote work and things of that nature now. So if you are writing out an employment contract for a company that you represent, remote work is happening. There's pressure now for greater transparency. Here are the terms of your employment, here's what you need to do, here's the salary, and it's supposed to be more open to all. How do you get to do that? How do you get to negotiate contracts for employment when, if you were working here in Rhode Island, you'd be paying a certain wage, but New York certainly has a different standard of living. How do you manage that? I mean, that certainly does change what a typical employment contract is going to look like to be fair.
Yeah, so the issue first and foremost is, are you an employee or are you an independent contractor? And so if you're in Rhode Island and you're an independent contractor for a company in California, then you're really operating out of Rhode Island, and they're paying you without probably any taxes coming out or any of those types of things, Social Security. You'd be doing your own self-employment taxes.
Yes.
and paying your own state and federal taxes. If you're an employee, it's a bit of a different situation, and it would be a real interesting question that you'd have to look into is, if I'm working in Rhode Island for a company in California, do I have to pay California taxes and Rhode Island taxes, and what's the rule on that? And that's something that I'm not familiar with, and I'm not 100% sure how that would work.
So we have talked about what qualifies someone to be really an independent contractor versus you just want to pay that person as an independent, but they really are an employee of yours. There are, I guess the Department of Labor has some very strict guidelines about what that means, and I don't know that those have changed much. Are you aware? No.
They're the same.
They're pretty much the same. So now that we understand if someone really is handling their own time, using their own typewriter,
their own equipment.
Their own equipment, on their own, to do it on Monday versus Friday. They just have to get the work in on time and to the employer's satisfaction. When they want to negotiate, whether it's a contract and wages, their time off, or even if, as we talked before about workers' compensation, if they're hurt, if they get hurt and they're working remotely, working out of their home, those are myriad difficult situations to deal with. How do you wend your way through that?
So an independent contractor wouldn't be subject to workers' compensation
at
laws.
all.
At all. If you're an employee and you're working at home and your computer falls on you and you get hurt and you're working on the computer in the course of your employment, it's probable that you would be able to recover workers' compensation for that. Query, if you took a break and went into your kitchen and burned your hand on your own stove, whether that would be deemed arising out of the course of your employment. If breaks are common and you're able to show that I didn't deviate from my work, I was just on my 15-minute break, you might be able to recover. If you left your home to go pick up your child at school and got into an accident on the way back, that might be a deviation from the course of your employment, and you might not be able to recover. And
then another little wrinkle, but not really a wrinkle, is what they refer to as there's a gig economy, there's a gig employee where certain activity is part of a larger process. You might be doing it through an app or a website, some other digital platform, and you work for a company that picks up people and gives them rides to work. Or you rent out your home and you're making income that when something happens, you're running errands or whatever for another company, all those little gig things, do those end up becoming part of, I don't know, an OSHA-based issue if someone doesn't have the right equipment in their car, or something happens to the car? Who do they sue, and what's happening with that gig economy, and who's getting sued, and who's covered by what?
So it's a very interesting question. I would assume, I don't know personally, that if you work for a company doing a rideshare type of thing, there must be some kind of contract that you have with that company that lays out what your responsibility is, what their responsibility is, and that type of thing. The more interesting question to me would be if you're the person getting picked up for that rideshare and there's an accident, who are you able to sue? Are you able to sue the person driving? Are you able to sue the company that they're working for, or an independent contractor for, if they are? And I, again, think there's probably, I don't use those things, but there's probably some information when you sign up for that app. But if they're an agent, the person driving for the company of the disclosed principal, I think you might be able to sue both.
I know you've often mentioned that you go for the deeper pockets. There's this at one level, but the bigger picture is another.
I think we would look for the bigger picture.
Of course, of course. So with the automation and AI, there are many people who were working. Now we don't need you. Many are being displaced. Do they have a legitimate claim that their work or employment has been terminated unfairly?
Well, I don't know about an unfair termination, but they certainly would have a claim for unemployment because they didn't do anything wrong, and they no longer are unemployed because they've been replaced, so to speak. Then they can collect unemployment. I don't know that what you're saying is that discrimination?
So maybe it is. Maybe someone's saying I'm being replaced. Well, let's talk about discrimination. So DEI has always, well, of late has been an issue, and we wanted to be very fair with DEI rules. Now there's a different kind of administration and a different kind of thought. And also it's impacting on who's being employed, what they're being paid, if they're being terminated. What happens to contracts these days with employees and employers?
The DEI issues that have come to the forefront with your administration, as you refer to it, I don't think have spilled over into what discrimination is, at least not yet. So if you're being discriminated against because you're a woman and you were fired from a job because you're a woman and you can prove that, or for some other reason that's a protected class, age, for example, I think those are still protected things that you can sue for. We'll have to see what happens if those cases get taken up. But
so interestingly, even in planning for this, when you think about AI having, you talked about hallucinations, there's also some, at times, built-in bias or discrimination that I don't know how you factor that in, and I don't know how to read the code line that tells that it's there, but you could very easily be discriminated against if that bot, if that AI program is selecting whether or not you have the job. Yes?
I can't answer that. I don't even know what all that is.
It's funny because there's so much of that that is becoming part of the court. There's going to be more litigation. I think it's going to keep our lawyers very busy.
Yeah.
We hope that this has been helpful to you, interesting to you. Please do continue to stay tuned to The Law Matters. It matters to you. Thank you.